When English colonists left for the New World, they brought royal charters that established the colonies. The Massachusetts Bay Company Charter, for example, stated that the colonists would have and enjoy all liberties and immunities of free and natural subjects. The Virginia Charter of 1606, which was largely drafted by Sir Edward Coke, stated that the colonists would have the same liberties, franchises and immunities as people born in England. The Massachusetts Body of Liberties contained similarities to Clause 29 of Magna Carta. When drafting it, the Massachusetts General Court viewed Magna Carta as the chief embodiment of English common law. The other colonies would follow their example. In 1638, Maryland sought to recognize Magna Carta as part of the law of the province, but the request was denied by Charles I. In 1687, William Penn published The Excellent Privilege of Liberty and Property, being the birthright of the free-born subjects of England, which contained the first copy of Magna Carta printed on American soil. Penn's comments reflected Coke's, indicating a belief that Magna Carta was a fundamental law. The colonists drew on English law books, leading them to an anachronistic interpretation of Magna Carta, believing that it guaranteed trial by jury and habeas corpus. The development of parliamentary supremacy in the British Isles did not constitutionally affect the 13 colonies, which retained an adherence to English common law, but it directly affected the relationship between Britain and the colonies. When American colonists fought against Britain, they were fighting not so much for new freedom, but to preserve liberties and rights that they believed to be enshrined in Magna Carta. In the late 18th century, the United States Constitution became the supreme law of the land, recalling the manner in which Magna Carta had come to be regarded as fundamental law. The Constitution's Fifth Amendment guarantees that no person shall be deprived of life, liberty, or property without due process of law, a phrase that was derived from Magna Carta. In addition, the Constitution included a similar writ in the suspension clause. Article 1, Section 9. The privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion, the public safety may require it. Each of these proclaim that no person may be imprisoned or detained without evidence that he or she committed a crime. The Ninth Amendment states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The writers of the U.S. Constitution wished to ensure that the rights they already held, such as those that they believed were provided by Magna Carta, would be preserved unless explicitly curtailed. The U.S. Supreme Court has explicitly referenced Edward Coke's analysis of Magna Carta as an antecedent of the Sixth Amendment's right to a speedy trial.